All right, everyone. Thank you for joining us this evening. Welcome to this presentation of Renting in Tacoma, offered by the City of Tacoma and presented by your Office of Equity and Human Rights. Today, we're going to delve into the updates for the Rental Housing Code and what to expect with Initiative 1 going forward. Throughout the session, we aim to provide a comprehensive overview of the current rental code in Tacoma. We'll explore various aspects from understanding the policies that are in place and what resources will be available and what enforcement will look like going forward. Please note that we won't have an interactive question and answer session during this presentation. We do encourage you to write your questions in the Q&A section of the Zoom webinar. You should find a button at the bottom of your screen and you can click there and write your questions there in that section of Zoom. Once the presentation is complete, we will end the recording and then offer time to answer all those questions that are written in that section of the chat. Please know that we cannot offer legal advice or interpretation of Initiative 1, and any questions related to that will be referred to seek outside legal counsel. This presentation is being recorded and will be made available on our website, ensuring accessibility for those unable to attend today. So feel free to revisit the content or share it with others who might benefit from the information shared here. So without further ado, I would like to introduce Chiquetta Elder as we go on this insightful journey into renting in Tacoma. And thanks again, everyone, for joining us today. And we hope you find this presentation both informative and beneficial. I am going to share my screen.
Thank you, Nancy. And I would first like to say welcome to everyone. And thank you for everyone who's taken time out of your busy schedules to join this Renting in Tacoma session. As Nancy stated, I am Chiquetta Elder, Landlord Tenant Coordinator for the City of Tacoma, out of the Office of Equity and Human Rights. And we're here to provide information on Renting in Tacoma, which will give an overview of the updates to our rental housing code that went into effect on July 24th of 2023. We'll also provide an overview of Measure 1, which is also now known as the Landlord Fairness Code initiative. And we'll also give an overview on how it's going to be implemented and different things like that. I just want to emphasize to everyone that the City of Tacoma's Landlord Tenant Code, Tacoma Municipal Code 1.95, the updates to that was adopted in July by council, and it was created with our rental housing advisory stakeholders group, which was comprised of landlord representatives, tenant representatives, city code, legal counsel. So that was a collaborative effort for the codes that were updated in July. So now we can move forward. Next slide, Nancy. So just a little background. In February 2019, the Tacoma Rental Housing Code, which is 1.9 TMC 1.95, it went into effect and it provided protections for tenants and guidance for landlords. In November 2021, the Rental Housing Code was updated to add the just cause eviction standards. Sorry, I usually say provisions. We have standards in the thing. I apologize. However, this requires landlords to provide one of the 16 specific justifications for filing an eviction. Then on July 11th, the City of Tacoma updated its rental housing code, which will be discussed in this presentation. And those changes went into effect on July 24th. And then last but not least, we will discuss the Landlord Fairness Code initiative, which is TMC 1.100, formerly known as Measure 1, and goes into effect on December 8th, 2023. Next slide. So we'll have a summary of the rental housing code updates. The updates that went into effect for the City of Tacoma's rental housing code strengthens requirements around notice to increase rent, shared housing standards, standards for fees and deposits, business license, health and safety requirements, rental agreement regulations, and standardized tenant screening criteria. Next slide. So a summary of updates continued in the Landlord Fairness Code Initiative, TMC 1.100. It establishes requirements around notice of rent increase, move-in costs and pet fees, late fees, evictions, relocation assistance, health and safety requirements, and enforcement and penalties. So the Landlord Fairness Code Initiative does not replace the Rental Housing Code. It does provide additional protections and expand on certain protections under the Rental Housing Code. Both codes will be in effect and landlords are required to comply with both. So just as when we created the city's Rental Housing Code, it did not replace the state's landlord tenant law. So landlords are required to comply with the following: the Washington State Residential Landlord Tenant Act, the Rental Housing Code, and the Landlord Fairness Code Initiative. However, the enforcement mechanisms for each of those are different. Under the state law, there's not an enforcement mechanism, there's only civil remedies. Under the Rental Housing Code, we do have an administrative process to do enforcement for violations of the Rental Housing Code, and the Landlord Fairness Code Initiative mirrors the state law that doesn't have an administrative enforcement process. However, it does have civil remedies that a tenant can take for violations. Now, the city of Tacoma understands that this is confusing and a little complicated, especially around some of the terms that are not defined. Therefore, the city will be providing guidance around some of the initiative to provide some suggestions on how the initiative works. However, the city may not be the guidance may not be available before December 8th, but it will be posted on the city's website as soon as possible. In the last session, there were a lot of questions around why the city wasn't going to enforce the initiative. And I just want to be clear that that is the way the initiative was written. It wasn't written to where it allows an enforcement mechanism by the city. So therefore, we have to comply with the way that the initiative was written. And it doesn't give us that option, whereas the Rental Housing Code is written that we have enforcement. Next slide. So now we'll go over the City of Tacoma's Rental Housing Code, which was adopted on July 11th and went into effect on July 24th, 2023. So these requirements went into effect on July 24th, 2023. So any landlords that have been operating and taking applications or entering into rental agreements or anything like that after July 24th were required to follow these provisions. So tenant screening. Landlords are required to provide the tenant with a written screening criteria based on your own business practice, information on the tenant's right to pay deposits, non-refundable move-in fees, and last month's rent and installments. The Rental Housing Code website to access information on code violations, findings and settlements related to housing discrimination under TMC 1.29, and information on how to register to vote. The Rental Housing Code website is cityoftacoma.org/rental housing code. Next slide, please. Tenant screening continued. Landlords cannot place a blanket ban on prospective tenants with felony or drug convictions or arrest records, cannot require a social security number as the only way to conduct a screening. Alternative proof to establish eligibility must be accepted, and must conduct individual assessments on the tenant's criminal history, such as the type and severity of the offense and how long ago the offense occurred. However, landlords can deny tenancy for criminal history based on a pending charge of conviction for sex offenses, violent crimes, arson, manufacturing, sale, or distribution of drugs, or unlawful use of buildings for drugs. Next slide. Okay, so tenant screening continue. Per TMC 1.95.035, landlords cannot exceed the maximum income to rent ratios when determining eligibility. If the monthly rent is below the HUD fair market rent, the income to rent ratio would be 3 times the monthly rent. So if fair market rent for a 2-bedroom is $1,987 and your rent is $1,500 per month, the tenant would have to have a monthly income of $4,500 to qualify at the 3 times the monthly rent. However, if the property is above the HUD fair market rent, the income to rent ratio would be 2 times the monthly rent. So if you have a 2-bedroom, if the fair market rent for a 2-bedroom is $1,987 and your rent is $2,100, that would be the income required by the tenant would be $5,250 a month to qualify. The fair market rent information will be posted on the Rental Housing Code website, but it's also available on the HUD's portal. So we'll have all that information on our website for you to access. Next slide, please. Rental agreement regulations. As I stated earlier, any rental agreements, lease agreements, all of those things that were entered into after July 24th, 2023 should already include these regulations. So per TMC 1.95.037, rental agreements must include the number of legal occupants as outlined in TMC 2.01.060V, list uninhabitable spaces such as attics, basements, and garages that have not been properly permitted for occupancy. And landlords are prohibited from assessing penalties or forfeiture of deposit if the tenant terminates the tenancy before the expiration of a minimum term month-to-month rental agreement. And then they're prohibited from regulating or restricting dogs based on breeds unless they have an insurance company required breed restrictions, and they must provide any breed of a service animal must be allowed. Next slide. Standards for fees and deposits. Per TMC 1.95.040, deposit requirements and installment payments permitted. Tenants will have more time to pay move-in fees dependent on the length and type of rental agreement. Landlords cannot require a pet damage deposit exceeding 25% of 1 month's rent. They're prohibited from retaining a full pet deposit if it's not used for the damages in the unit caused by the pet. TMC 1.95.065 late fees. Late fees cannot exceed 1.5% of monthly rent with a maximum limit of $75 per month. Requires the landlord to take active steps to recover late fees during the tenancy by serving quarterly notices and invoices. And it prohibits landlords who do not take those actions to recover the late fees during the tenancy from withholding it from the deposit or reporting the information of the late fees to a prospective landlord. Next slide. So business license and safety requirements. A landlord will not be able to pursue eviction or increase rent without a current city business license, or if the dwelling does not comply with RCW 5918.060 and presents conditions that endanger or impair the tenant health and safety. Next slide. Shared housing standards. For shared housing arrangements where a tenant rents a room or private or shared room, but shares common areas such as a kitchen, gathering spaces, and or a bathroom with other tenants, the following requirements will apply. The master leaseholder must share contact information for any subleasing tenants with the landlord and the landlord's contact information with any subleasing tenants. When renting to 4 or more tenants, separate rental agreements for each habitable space are required. Landlords is required to serve any notices that can lead to eviction to the master leaseholder and provide the master leaseholder with additional copies of the notices to serve each subleasing tenant. If the subleasing tenant is not provided a written notice of eviction, the landlord must allow the subleasing tenant an additional 30 days to vacate after the eviction order is issued or as ordered by the court. Next slide. Oh, notice of rent increase. I'm sorry, I couldn't see what the title was. Per TMC 1.95.060, rent increases requires a written notice of at least 120 days for rent increases before it can go into effect. Requires that the written notice be served in accordance with RCW 59.12.040. Requires summary of resources to be provided as outlined in TMC 1.95.030, and it prohibits the landlord from charging the tenant for the rent increase notice to be served. However, again, I would like to stress that although our code says 120 days and the Landlord Fairness Code says 210 days, it is the city's expectation for landlords to comply with the requirements under the Landlord Fairness Code. And so a note on rent increase notices. Subsidized tenancies under RCW 5918.140 subsection 3 and deed restricted affordable housing only need to provide a 30-day notice of rent increases to their tenants. Next slide. So now we'll dive into the Landlord Fairness Code initiative a little deeper. Again, this is just an overview. All the questions are not going to be answered, and we will be producing that guidance. But the Landlord Fairness Code initiative went into effect on December 8th, 2023. Will go into effect, I'm sorry. So the rent increases, fees, and move-in costs. Under the Landlord Fairness Initiative Code, it requires 2 notices. The first notice of rent increase is between 210 and 180 days before the rent increase takes effect. The second notice, which is known as a reminder notice, is required between 120 and 90 days before the rent increase takes effect. Under the Landlord Fairness Code, as it relates to late fees, the late fees cannot exceed $10 per month. Move-in costs. Total for all move-in costs cannot exceed 1 month's rent. Pet damage deposit cannot exceed 25% of the first month's rent and must be refundable if no pet damage is done to the unit, which mirrors the city's rental housing code. And it prohibits all other non-refundable fees except those that are allowed under the state law. Next slide. So the next part of the initiative or the Landlord Fairness Code is defense to eviction. The following forms of eviction are prohibited. School year, where a person having legal custody of a child or student, including but not limited to the child or student's parent, step-parent, adoptive parent, guardian, foster parent, or custodian, or an educator. So those evictions are prohibited during the school year. Winter evictions, where you require the tenant to vacate between the months of November 1st and April 1st. And then the protected classes of tenants. A tenant cannot be evicted based on their status as a member of the military, first responder, senior, family member, healthcare provider, or educator. So the exemption to the school year and the cold weather evictions are: owner or immediate family member needs to occupy the unit, unit has been condemned, landlord is sharing housing asking a roommate to vacate, sexual harassment by the tenant, drug-related nuisance on the premises, waste nuisance or or unlawful activity on the premises, a tenant's conduct has a substantial detrimental impact or causes an immediate threat to the health and safety of other tenants or the owner. Note, a landlord can seek court order to be exempt from these provisions and allow eviction if they can show they would experience an undue and significant hardship if the code were enforced. Next slide. Okay, the next part of the Landlord Fairness Code initiative is the relocation assistance. If a tenant's rent is raised 5% or more, and the tenant decides to relocate, the landlord is obligated to pay relocation assistance in the following amounts. If the rent increases 5% to 7.5%, the relocation assistance is 2 times the monthly rent. If the rent increases 7.5% to 10%, the relocation assistance is 2.5 times the monthly rent. And if the rent increases more than 10%, the relocation assistance is 3 times the monthly rent. In the event that a tenant is unable to relocate and remain in the dwelling unit at the increased rent and has already received relocation assistance, they must pay the relocation assistance back. There are some exemptions for having to pay relocation assistance. A landlord and a tenant are living on the same site if the site has 4 fewer dwelling units. Tenants who have lived in the dwelling unit for less than 6 months. A landlord that temporarily rents out their primary residence during the landlord's absence due to active duty military service. Those are the exemptions under the relocation assistance. Next slide. Health and safety standards. Landlords must comply with all tenant protection laws. Landlords in violations of such laws may not increase the rent or evict the tenant. Requires landlords to have no violations under TMC 2.01.050, the minimum buildings and structure code, or violations under RCW 5918.060, which can make the unit uninhabitable. So under the enforcement and penalties, landlords who violate this chapter can be liable for penalties of no less than $500 and up to 5 times the monthly rent of the dwelling unit at issue per violation. So it's up to $500, no less than $500, up to 5 times the monthly rent per dwelling unit with the issue, and it's per violation. And then the tenant can sue the landlord for violations, and a tenant or an organization can sue for injunctive relief. Next slide. So managing the differences. The Landlord Fairness Code Initiative and the Rental Housing Code have separate and distinct enforcement mechanisms. As I explained earlier, the Landlord Fairness Code has no authorization for an administrative enforcement by the city, and its provisions are enforced exclusively by private rights of action. A tenant can seek to enforce the initiative's provisions regarding the late fees and a notice of rent increase through legal actions taken against the landlord. The Rental Housing Code is enforced through the city's administrative process. The city may enforce the Rental Housing Code related to its provisions for the late fees and the notices of rent increase. And the reason why we did that is because those are the two conflicting issues, is the notice of rent increase and the late fees. However, as I explained earlier, it is the city's expectation that landlords are in compliance with all of our codes, which include the Landlord Fairness Code. Even though we can't enforce on it, it is an expectation if you're operating rental property in the city of Tacoma that you're complying with all of our codes, in addition to the state law as well. Next slide. So I think I kind of touched on it, that there's the two conflicting things, which include the late fees, where the Landlord Fairness Code caps it at late fees of $10, where the city's caps it at $75 in our rental housing code. And then rent increase notices, the Landlord Fairness Code requires 2 notices to increase rent, starting at 210 days versus the rental housing code's 1 notice at 120 days. And again, landlords are expected to comply with all the requirements of the Landlord Fairness Code initiative as it pertains to rent increase notices and late fees, as well as everything else that's outlined in the initiative, the Landlord Tenant Act, the Landlord Tenant Act and the City of Tacoma's Rental Housing Code. And that is the end. And thank you.
That is the end. Of the presentation part. So let me stop sharing. And then Raquel, if you would do us the honors of walking us through the questions.
Yes, thank you. Okay, so I've been answering them on the side already, so I'm just gonna, this is a good one. I believe is it Erme? If I'm selling my rental property, can I still give them a 120-day notice to vacate in the winter times as long as the date to vacate is after April 1st?
Can you repeat the question?
If I'm selling my rental property, can I still give them a 120-day notice to vacate in the winter time as long as the date to vacate is after April 1st? I think they're talking about the winter evictions.
Again, my suggestion is that you seek legal advice because under just cause eviction, it does allow a landlord who's selling their property, but there are some exceptions to winter evictions, and that isn't one that was listed. So you would need to seek legal advice from an attorney as to whether you can still do that in the winter months.
Sorry. The next one is from Allie. It says, when does the landlord have to pay the relocation assistance? And then the second part is, what happens if tenant takes relocation assistance and does not move out?
Okay. So if you look at the 100.100, it does give those exact outlines in there, but it is within 30 days of the tenant making the request to the landlord. And it does state that if the tenant does not relocate after they receive the relocation assistance, they do have to repay the relocation back to the landlord.
Perfect. Jennifer asked, are we required to allow pets now?
No, it doesn't state that you're required to allow pets. So a landlord can still have a no pet policy. It just had restrictions on breeds. So if you were to say that you accept dogs, you can't just have those breed restrictions. However, as in any other situation, if it is a service animal, a therapy animal, or anything like that, you are required to accept animals, even if you have a no animal policy. But as far as now you have to accept pets, no, you don't.
Okay, Ermi put, how does this apply if tenant is subletting without landlord's knowledge or permission?
Can you repeat the question, Raquel?
I think when you were talking about the master lease holder and then making the landlord aware, and they're asking how would this apply if they're subletting and the landlord doesn't know and didn't give permission?
So under the rental housing code, if you weren't aware, but then once you serve the notices to the tenant and they now let you know that they have been living there and provide you with proof or something, I would consult with your attorney. But yeah, once you are aware that they're living there, you would still, if they can show that they've been subleasing and that they're a legal tenant there, you would still have to comply with all of these rules. But that's when you would enforce your rental agreement the same way you would for any kind of violation.
Okay. Brandy put, so who is going to cover the landlord's late mortgage? Since tenants cannot be evicted, where's the help for homeowners?
Again, this was not adopted by council or the city. This was a tenant's initiative. And so there isn't anything in place right now to cover mortgages or anything like that. again, I would consult with an attorney to see if you meet any of those legal exceptions or anything, because you do have some things under the Landlord Fairness Code that you can do. So always seek legal advice. But I know that, again, that this was not adopted by City Council.
First name Thacker, can the rent increase happen during the lease term if provided proper notice, or does it have to happen simultaneously with the lease renewal?
No, lease increases can never be increased during in the middle of a fixed term lease, whether the updates to the code or not. That's under the state landlord tenant law. You can't increase rent in the middle of a fixed term lease. It has to happen at the end.
Allie put, when does the landlord have to pay the relocation assistance? Oh, this came twice, so I'm gonna remove this. Sorry, guys. You already answered that. Okay, the next one, Jennifer. Would these relocation fees be required on a tenant that has only been there a few months? When does this kick in?
Well, all of this starts on December 8th. But again, one of the exceptions was that if the tenant has lived in the unit less than 6 months, the relocation assistance does not apply. That was one of the exemptions.
Okay, the next one is from Thacker. If the city code and Measure 1 are contradictory, which one applies?
Both. A landlord is required to comply with both. Again, there's just different enforcement mechanisms that can be applied or exercised. However, the city expects anyone who's operating rental property in the city of Tacoma to comply with both, in addition to the Washington State Landlord Tenant Law, Washington State Residential Landlord Tenant Act.
Okay. And Justin wrote, what happens if you have a lease coming to an end within the 7th-month notice since the December 8th effective date, say April 30th? What's the notice policy there?
So the lease ends April 30th?
Mm-hmm.
So they would still have to comply with, if they wanted to increase the rent, they would still have to comply with the notice provisions. If you're going to increase the rent, some landlords do the thing where they will have the tenant sign a new lease and then they agree to everything and they've given them proper written notice. And then the provision about when the money changes or the rent increases it'll say like May 1st, but they've given them that 6-month notice, but like they'll sign the lease, but the rent part can't start until after the proper 210 days has expired.
I don't know the name, but it says iPhone. What does this mean for people who are in current eviction status with school children?
I would seek legal advice because it doesn't go into effect until till December 8th. So I would reach out. If you're low income, you can reach out to like Tacoma Pro Bono. If you're not low income, you can contact the Tacoma Pierce County Bar Association. They have a lawyer referral line where you can get legal assistance. And then there's also the Moderate Means program. But I would seek legal advice because, again, this does not go into effect until December 8th.
Okay. Samantha wrote, for relocation fees, is it 2 times the current rent?
So if it is above, if it's 7.5 to 10%, it is 2.5 of what the rent was at the time of the notice, not the rent increase.
Okay. Scott is asking, can the rent be increased 5% every month on a month? I think they mean on a month-to-month lease.
It can't be increased every month because you got to give a 7-month notice under the initiative. So it's either it's between 7 months and 6 months. So you can't increase it every month. That wouldn't be possible. So I guess the answer is no.
Stephen wrote, what does it mean that a tenant cannot be evicted based on their status as a member of the military, first responder, senior? Can you provide an example?
There's definitions in if you look at the TMC 1.100, it does have definitions in there. But so an example of a first responder would be like a police officer or a firefighter or a health care worker, something like that. Yeah. So those would be an example of a first responder.
Attorney Chris wrote, is it your understanding that the code sets minimum requirements for the term of the lease agreement? In other words, what is stopping a landlord from creating a 6-month rental agreement as the new standard instead of a 12-month to avoid the rent increase requirements?
They would still have to, if they're going to increase the rent into a new lease, even if they only do 6 months, they're still going to have to do that. So it would be to where the rent increase could go into another term. So I would talk to your attorney before you do any of those things, because you could find yourself having action taken against you for those types of things. So that's something that we can't really provide guidance on, but those requirements are still going to be there.
Justin asked, late fees, is that per month, per week, or per day?
Per month. $10 per month is the max, is the cap on what you can charge for a late fee. So I know some landlords used to charge, they'll do like $10 and then like $5 per day and stuff. That cancels all of that out. $10 is the cap on late fees.
Okay. Colleen wrote, what is a move-in cost exactly? Does that total include pet and other deposits?
All things related to move-in costs, which would be the deposit, the move-in fees, the non-refundable administrative fees, all of that a landlord charges cannot exceed 1 month's rent.
Okay. Stewart asked, how can we sell our property under these restrictions?
That's a question that I would seek legal advice on. Well, we would hope that you wouldn't sell your property and review the code and seek legal advice on how you can still operate your rental housing in Tacoma under these provisions. But again, I would consult with an attorney, but we're hoping that you won't sell your rental property and that you'll find a way to work with these provisions as outlined.
Well, we had this one earlier, but Dan asked, for landlords that gave 120-day notices to raise rent in August, effective January 1, is this still okay?
So you gave the 120, so if you gave the 120-day notice, I would consult with an attorney to see what their advice would be, because if you gave the proper 120-day notice when the rental housing code was in effect, then that would not be something that we would enforce on. However, there may be things that a tenant could seek outside of, under the Landlord Fairness Initiative Code. So I would consult with your attorney to see if that was still, if they still recommend that will still apply, or if you need to do something different.
Janie is asking, this sounds like a bureaucratic nightmare. What if the landlord observes the city enforced rules, but not the Measure 1 rules? The city could not enforce the more rigorous requirements, or could they?
As I explained earlier, the way that the Landlord Fairness Code initiative is written, it does not have the section that is not written so that the city can enforce any violations of the Landlord Fairness Initiative Code. A tenant would have to seek civil remedies. Now, we can only enforce what has been adopted in our codes by the city council that does allow the administrative enforcement process.
Okay. Silva's asking, what is the requirement to end the lease at the end of the lease term? 90 days still, or is it now 120 days with no just cause?
There's no such thing as a no just cause in the state of Washington anymore, and it hasn't been one since May of 2021. Just cause evictions provisions were adopted. The only time the no cause goes into effect is if a landlord and a tenant had just entered into, it was the first year's lease. At that time, the landlord can give the 60-day notice under the just cause provisions and not have to give a reason. But other than that, if a landlord is going to terminate a tenant's tenancy, they have to have one of the 16 just cause eviction reasons. And those notices range from 3 days for like waste nuisance or illegal activity to 120 days if the landlord is going to demolish, substantially rehab, or change the use of the property. So I would suggest that you look at those provisions and speak with your attorney to see if which one of those provisions applies to you ending the rental agreement with your tenant.
Bonnie's asking, are there different requirements for short-term rentals?
No, unless it's like Airbnb or something like that. But if it's under regular landlord tenant law and you don't fall into any of those other classifications where there's exemptions under the state landlord tenant law, then no.
Samantha's asking, do you have to sue the landlord if they don't help with relocation fees since it is not enforced?
Correct, you would.
Okay. Rita's asking, if an educator loses their job, does it mean they're no longer an educator and can be evicted?
That is a question. That's one of those things that's kind of that vague area under the Landlord Fairness Code initiative that we would suggest that you seek legal advice on, because we can't answer that question and we can't interpret it as a city.
Eugene's asking, if tenants receive relocation assistance from the homeowner, let's say 4 times the monthly rent, and they use only the amount of 2 times the monthly rent to relocate, should they be required to refund the remainder?
There's nothing in the initiative the only time the initiative speaks about a tenant returning the relocation cost is if they receive it and then they decide that they're unable to relocate, and then they remain in the unit at the higher rent increase, then they have to return the relocation cost to the landlord. It doesn't say anything about whether their relocation actually only cost them 1 times the monthly rent and they've gotten this additional money. It doesn't speak to that. So that's not outlined in there, but I would speak with an attorney. But the only time they speak about returning the money to a landlord is if you stay in the unit after you receive the relocation funds.
Okay, Anna's asking, if you have an end date on a yearly contract and are not planning on renewing the contract, do you still need to do the 2 notices to vacate?
There's not a requirement under state landlord tenant law or the city's rental housing code for 2 notices to vacate. The only time 2 notices are required is if you're if you're increasing the rent. The same provisions under the state law and the rental housing code as outlined now is you just have to give the proper written notice, make sure it's served in the proper manner, and that it includes the proper resource forms that are required by law for the rental housing code.
Paul's asking, in regards to the exceptions for evictions for landlords who can show it would cause an undue hardship, at what point in an eviction process prior to now, 3-day notice, would you ask the courts for the exception?
That's a question that we can't answer. I would seek legal advice on that. That's something that the city can't interpret.
Okay, Dan's asking, is the city considering setting up escrow accounts to hold the relocation funds as tenants have no time requirement to return the money? Could be 10 years.
No, that is not something that the city is looking at. And again, this is something that we did not adopt as a city, and we just have to comply. And so I would seek legal advice on how you can, what ways you can go after the tenant if they don't return the relocation costs in a timely manner.
Nan's asking, under protected class, what is the family member? What does that mean? I know we had gone over this in the last one.
Yeah, the definitions are there in the code, and it explains what that would mean. So I would suggest that you go directly to the code and look at the definition.
Theobon is asking, is there now a cap on deposit?
Is there now a cap on deposit?
Yeah.
It is not saying that there is a cap, but it does state that all move-in fees, including deposits and non-refundable fees and things like that, can't be more than 1 month's rent. So there's not outlining that there's a cap, but you have to take all those things into consideration when you're doing all of your fees and move-in costs.
Sorry there. Okay, so Jamie's asking, how does this Measure 1 help provide more rental units at affordable prices since many mom and pop landlords will be selling out?
Can't answer that question because, for one, this is just now, it's just now going into effect. It hasn't been implemented. And then again, this isn't something that the city implemented into our code. So I can't answer that question, unfortunately.
John's asking, why the difference between the Fairness Code and Rental Housing Code? But we are expected to adhere to the Fairness Code?
The difference is the city implemented one ourselves, and then the other one, it was voted on by the people of Tacoma. So the city, if it's voted on by the city, by the people of Tacoma into law, we are expected as a government entity to comply with that. And so we have our own rental housing code that has some things that have different protections in it that the Landlord Fairness Code initiative does not. But because both of them are law, people who are operating or living in rental housing in Tacoma are required to comply with both codes.
Okay, Dan's asking, when will the city have the rent increase notice form available? City is required to prepare this. I believe we are not allowed to use our own forms now.
They will be updated on the website ASAP, hopefully within the next couple of days, but it definitely will be by the time that the code goes into effect on the 8th, which is Friday.
Okay, Shannon's asking, are you considered a landlord if you have an owner financing contract wherein the person living in your home will eventually be buying the house from you once they secure financing?
If they're paying you rent, yes.
Grant's asking, I have a single family rental home. If I have someone who hasn't paid rent for several months and now it is November 1st, I'm not allowed to seek eviction until April 1st of the next year?
I would seek legal advice on that because, again, there are some exceptions. You may be still able to go through the process, but you can't require them to vacate until the end of the term. But again, you need to seek legal advice because, again, there are some exceptions that landlords can go through with those codes being in place.
Donna's asking, as a landlord, if the tenant does not pay any rent and we cannot evict until after the winter is over, is the tenant still liable for rent?
Yes, they are, just as they would be in any other judgment. So like if you were to take them to court for a regular eviction and they would still be required to, they're still required to pay that rent or responsible for that rent. This only is stating that you can't ask them to vacate the unit during these certain periods of time, the school year and the winter months, but it doesn't take away the fact that they still owe the rent.
Emily's asking, if a lease is up, can the rent be raised when making a new lease without having to pay relocation fees?
If it's over 5%, no.
Okay, next one, Dan is asking, is the income 3 times the rent or 2.5 times net or gross?
The rent to income standards.
Yeah, I believe so. They're talking about.
So the rent to income ratios are always based the same way, that it's off of the gross income. So if it's below HUD fair market rent, and you would be doing the 3 times the monthly rent, and if it's above, you will be doing a 2.5, but it's off the gross income.
Okay. Rochelle's asking, why can't rent be increased every month if notice provisions are met?
If it requires a 6-month rent increase notice, how is it possible to increase the rent every month? So, I mean, I would seek legal advice to figure out how that would work on a month-to-month rental agreement, because you are going to be required to give a 6-month lease. So if you're saying that you want to give a 6-month rent increase notice every month, and then it increases in January, and then you've already given the next notice, and then it increases in February again, I would talk to an attorney about that, because that might not be a good business practice, but it is still a little questionable as to how that will work.
Okay. The attorney, Chris, again is asking, can relocation assistance be paid out of deposits?
No. No, a tenant would be entitled to their deposits and everything under the state law as outlined. So if they don't cause any damage to the unit, things like that, you will be required to follow the state law as it is around how you handle deposits and the return of security deposits. So the relocation cost is in addition to all of the other provisions that are required under the Washington State Residential Landlord Tenant Act.
Ricky's is asking, what are the penalties for each specific action that might be taken? Who collects the penalties? I think underneath our code, the rental housing code, the enforceable side.
If you're talking about the city's and rental housing code, depends on what code it is. So like it's broken up into 2 different penalty phases. So for things such as not providing the written in Tacoma booklet, or not providing certain notices, it's a blanket $500 penalty the first time, and then it increases to like $750. But things like not giving proper notice of to terminate tenancy, not following the relocation assistance that's under the city's code for substantially rehabbing the property, renting, and then like for rent increases and stuff like that, it is $250 per day for the first 10 days, and then $500 per day until you come into compliance. And then that is collected by the city just like they would for any other violation under our codes. If you're asking about the Landlord Fairness Initiative, those penalties again vary from anywhere from $500 to 5 times the monthly rent. And those are collected by the tenant and or any organization that is suing the landlord on behalf of the tenant.
Okay, Kathy's asking, if the lease expires and the landlord does not wish to renew with the current tenant, does that tenant then have to move out at the end of the lease?
if the landlord has one of the just cause reasons and they serve the proper notice, then yes.
Stephanie's asking if the applicant is on a voucher program, is the 1 month cap for move-in based on the total rent amount or the tenant portion amount on the voucher?
The total rent amount.
David's asking, are there limits to monthly fee increases, monthly pet fees, or utility fees?
Can you repeat the question?
Are there limits to monthly fee increases, monthly pet fees, or utility fees?
So you have to understand that under the Landlord Fairness Code initiative, it restricts landlords having these additional fees. So like monthly pet fees, monthly things like that. So you would have to talk to your attorney. So, and then there is a limit on how much of the deposit you can accept for a pet, which is no more than 25% of the first month's rent. But I would speak with your attorney, because with the initiative, it prohibits fees that aren't outlined in the RLTA.
Okay. Kathy's asking, would the landlord have to pay relocation costs by not wanting to renew the lease with a given tenant?
No, the only time a landlord is required to pay relocation costs under the city's current rental housing code is if they're going to substantially rehab the unit, demolish it, or they're going to change the use. Under the Landlord Fairness Initiative, there's nothing, the relocation is only around rent increase notices and a tenant's inability to either, or if a tenant chooses not to pay the new rent increases, that's where relocation comes into play. But if the landlord is just ending your tenancy, no, they're not required to pay relocation costs if it doesn't fall into one of those two areas.
Okay. Samantha's asking, so can the tenant sue me for relocations fee if I don't pay them? Does the tenant have a right to sue me for this?
They do. Under the Landlord Fairness Initiative Code, initiative, that the landlord can be sued if they don't pay the relocation costs.
Grant's asking, I have a single family rental home. If I have someone who hasn't paid rent for several months and it is now November 1st, am I not allowed to seek eviction until after April 1st of the next year?
Correct. I mean, you would speak to your attorney to figure out what your options are, but that is what the Landlord Fairness Code initiative is stating, that you cannot evict tenants for non-payment of rent during those months.
So this sounds like a clarifying question from Justin. So at the end of the lease, are you saying you can't just not renew a lease? You have to fit in one of those provisions?
Correct. Under state law, you have to have a reason to terminate someone's tenancy. So that those provisions can be found in the city's rental housing code, but it's also under the RLTA is RCW 59.18.650. And they list out all of the reasons and all the time frames in which a notice can be a tenancy can be terminated under the just cause eviction.
Okay, this one says by Attorney Chris, Measure 1 defines an eviction as an effort by the landlord to terminate or discontinue the tenancy through any means, including unlawful detainer, refusing to offer a new lease, or seeking a mutual termination agreement. Section 9, is it the city's understanding that refusing to renew a lease to a tenant who is not paying during the eviction moratorium period constitutes an unlawful eviction?
Again, the city will be offering guidance, and I'm not sure if this will be on there, but we are not doing a lot of interpreting what we believe that the code, the initiative is saying. We will just be providing suggestions and information on how you can find this out, but we won't be doing a lot of interpreting what we believe they meant when they wrote the code.
Okay, Rita's asking, does city need to be emailed copies of the rent increase notices?
The only time that the initiative states that the landlord must provide the tenant and the city with anything is if the tenant requests relocation costs. So the landlord is supposed to provide the tenant with a copy of that request and then proof that the relocation assistance has been paid. Other than that, there's nothing in the law that says that they have to notify the city of rent increase notices.
Okay, Joanne's asking, how long does a tenant have to relocate or vacate the unit after receiving the relocation assistance?
They have until their notice expires. I mean, until the new rent goes into effect. So if the new rent is supposed to go into effect in April and they requested the relocation and then they give a notice to terminate tenancy and letting the landlord know when they're moving out, then they have until the new rent goes into effect.
Judith is asking, are disabled people included in the special population group with no winter evictions?
Can you repeat the question?
Are disabled people included in the special population group with no winter evictions?
All tenants are included in winter evictions for non-payment of rent. It doesn't have specify a certain category of people. It's just no winter evictions for non-payment of rent. And then the school year is where they kind of, and educators in the protected classes, they go into a little bit different, but everybody is protected under the winter evictions.
iPhone user saying, so is anything that's gone on prior to December 8th null and void as far as deposit, late fees, etc.? Do they have to remove late fees off our account?
No. If they would have to still comply with the city, but moving forward, they would have to do the late fees as it is outlined in the new code. So $10 per month moving forward. If it was like the 1.5% was $15, now they wouldn't be able to do the 15, they would have to do the 10, but they're not obligated to wipe out anything that was in the past that's old.
Lisa's asking, if move-in fees cannot be more than 1 month's rent, is the expectation then for a payment plan to be created for the security deposit, last month's rent, etc.? If so, are there time restrictions to follow on such a plan, like 3 months, 6 months?
Yeah, under the city's rental housing code, there is, depending on how much the amounts are, there is you would have 3 months, and then there's 6 months, and then I think the highest is 6 months for them to be able to pay for the relocation. I mean, for the move-in fees under the city's rental housing code. So yeah, there are different timeframes, but it's based on how much the rental housing, the move-in fees are.
Min's asking, how many days does it take for a notice to sell? And what will happen if the tenant refuses to leave after the notice?
So if you serve your tenant a notice to sell, which under state law in the rental housing code is 90 days, and then you give the tenant the notice to the 90-day notice to terminate tenancy, and the tenant refuses to leave, you would still have to follow the same eviction process that you would in any other proceeding, if like notice that you had given the tenant. So if you don't, you as the current owner does not do it, the new owner now would have to follow the just cause provisions to get rid of the tenant, and it would have to be in one of the outline reasons as to why they're terminating the tenancy.
Okay. Danny's asking, if an initiative was approved by the voters but not put into law by the city, and the cap on all rental units was 1,000, would the city publish that as a requirement for landlords? How can any of these rules go into effect without providing any replacement income for landlords?
Can you repeat the first part of the question again? I'm sorry.
Hold on, sorry, I don't know how to get it back. Hold on. I'll come back to that at the end. Sorry, let me keep on the open.
Okay.
Okay. Brandy Brown is asking, we have to provide a copy of Renting in Tacoma booklet or else we will be fined.
Correct. And that booklet will be updated. And that's always been a part of the rental housing code. If a landlord does not provide that book, it is a $500 penalty.
Okay, Robin's asking, if the resident that chooses to get the relocation assistance decides not to move, are they then held to the new rental increase amount?
They are. And if they get the relocation assistance, they have to pay the relocation assistance back to the landlord.
Okay, Grant's asking, so as a landlord, my tenant's lease is about to expire and I do not want to renew it. In the way you answered someone else's question, you stated that the landlord would have to have a justifiable reason to not renew the lease. This makes absolutely no sense. If the lease is up, why, as a landlord, should I have to have just cause to not renew it? The lease is up, period.
That's under state law. That's the way the laws are written. They took away no cause evictions under the state law in the state of Washington, except for in one exception, as like I said, if it's within the first lease, whether it's a 12-month or if you have like 2 6 months and that term of a year and you want to terminate the tenancy, the law says that you don't have to give a reason. You just have to give the proper 60-day notice. If you have a lease that ends on such and such date, and you have one of those just cause reasons or whatever, you can use that, but it would be at the end of the tenant's lease term. So they wrote it into state law. That has been in state law since 2021, and the city just adopted the same provisions so that we can have enforcement around it, but it's under the state law that you have to have a reason to terminate a tenancy, even in a fixed term lease.
Okay, Siobhan asked, does the city's code also include the 4-unit dwelling requirements, meaning these codes don't apply to owners that own less than 4 units and lives in one of those?
Can you repeat it? Because
Yeah, so does the city's code also include the 4-unit dwelling requirement? Meaning these codes don't apply to owners that own less than 4 units and lives in one of those units.
You must have misunderstood. It doesn't say that all of these codes don't apply. The only thing that did not apply was the relocation assistance with a landlord who lives on the same site with the tenant and there's 4 or fewer dwellings on that site. That was the exemption. There's no other exemption about 4 units or less. The city's rental housing code applies to anybody who owns or operates rental housing in the city of Tacoma, even if you're just renting a room. These provisions still apply.
So I'm going back to the last question that, thank you, Nancy, for grabbing that. If an initiative was approved by the voters, but not put into law by the city, and the cap on all rental units was $1,000, would the city publish that as a requirement for landlords? How can any of these rules go into effect without providing any replacement income for landlords?
Again, the city did not adopt this. It was adopted by the people, so we have to put it into law. And there wouldn't be any, under the state law, there's no way that there can be any caps because there's a clause in the state law that does not allow a city to put a cap on like rental amounts or anything like that. So I hope I'm answering that question correctly, but yeah, the city is not putting this into law. We just have to comply because it has been voted into law by the community. This isn't something that the city has adopted themselves, but we are going to comply with it because we're legally obligated to do so.
Anna's asking, when it comes to the Landlord Fairness Code, were landlords part of this process? If a tenant doesn't pay during the winter months and leaves the landlord without options to evict, you are leaving the landlord with a financial burden. You are basically trying their hands of any recourse. How is this landlord fairness?
Again, this was not something that the city or the city council adopted. This was put in place by the voters. And landlords did have the opportunity to vote, which a lot of them did. As you can see, that it was a very close race, if that's what you want to call it. But again, this is nothing that the city put into place. And so when you say were landlords a part of the process, I know that they were aware of it because I know that there were a debate that went on against from the landlords organizations and the people that wrote the initiative. So the landlords were aware of it. They were fighting against it. But again, this is not something that the city put into place. Council did not adopt this. However, we are legally obligated to comply with it. And then therefore, that's why we're doing this session and moving forward. We will have an additional information to help clarify things and help people to come into compliance or to understand their rights and requirements under all of the codes that are required for renting in Tacoma.
Okay, I'm gonna scroll down and get to the bottom of the list and try to work my way back to the top. But it says, Justin, so if I own a 2-unit duplex and I live in one of them, the relocation fee does not apply?
If you live on, what the exception says is if the landlord and the tenant live on the same site and there's 4 or fewer dwelling units, then the exception, there is an exception for relocation assistance requirement.
Okay, Min's asking, if tenant refuses to move or pay back the relocation fee, then will that be a small claim court lawsuit?
So if they don't pay back the relocation assistance, then you would have to seek legal advice on what kind of action it would be that you would bring forth. But like if they've given notice that they're going to move out and then they don't, and they like don't rescind that notice and start paying their regular rent, I would seek legal advice, but I'm sure that you would be able to do the same unlawful detainer process that you would do in any case if that was in any situation if that was the case, if I'm understanding you right. But if it's just about the tenant not paying the relocation assistance, you would need to speak with an attorney to figure out which is the most appropriate form of legal action you can take. Because it may not be small claims court. It may be some other kind of action.
Paul's asking, what stipulates a reason a tenant might not pay rent? Loss of job? Is there any provision for the landlord whose tenant decided to not pay rent even though they are still working? What's to stop all tenants from not paying their rent?
So there isn't any provisions as what constitutes legally for a tenant not to be able to pay their rent. I can't say that there's anything that would stop tenants to stop paying their rent. However, I can tell you that it is highly discouraged from both landlord tenant attorneys that work with tenants, different things like that, because again, they're still going to be liable for the rent. And then if they have these evictions on their records, it could make it harder for them to find another place to live. So there isn't one thing that constitutes a right for someone not to pay their rent. People could choose to do this, but just know that they're not being advised to do that. And there's not really any benefits for a person to do that if they're going to need rental housing in the future.
Okay, Emily's asking, is it considered an eviction if the lease is up?
The only time anything is considered an eviction is if you go through the courts to terminate their tenancy. However, if the lease is up, you're still required to have a just cause reason and give the proper notice to terminate tenancy. But the only way it is an eviction is if it goes through the unlawful detainer process. That's where it's considered the eviction, but the termination of tenancy and all of that stuff does come into play. So if you're asking, with the winter months and stuff, if you give a notice to terminate tenancy and all of that, there's these protections there where you can't really do that. So I would always seek legal advice.
I think there's still some confusion. Grant saying, I wasn't asking about terminating a standing lease. The lease is about to expire, come to an end. Why should I have to have a reason to not renew a lease with the tenant? The lease is up in its completion, and I don't want to renew it. Why am I under any obligation to have to renew a lease with the current tenant?
My suggestion is that you speak with your attorney because they would better be able to explain that. But under the just cause eviction things under the state law, it does put that a landlord even with renewing leases and different things like that, you have to have a justifiable reason or a business reason to terminate someone's tenancy, even if it's a lease and the lease is expiring.
Burley's put, I own many properties in Tacoma, but live in Pierce County. I was unable to vote on Measure 1. How is that fair? How come landlords that paid the city of Tacoma rental business license but don't live in the city weren't able to vote?
I can't answer that question. That's just the way that the initiatives are set. I mean, that's just the way the voting things are set up. It's only for people who live inside the city limits of Tacoma that have the right to vote. So I can't answer that question. I am sorry. Maybe you can contact like your council member or someone and they would be able to better explain that. But that is just the way that is set up, that if you don't live inside the city limits of Tacoma, you can't vote.
Tammy is asking, do we still have a law where a person on a voucher, their 3 times income is based on the portion they pay?
Correct. That's under the discrimination code. So the Section 8 protections in the city of Tacoma's TMC 1.29, where a landlord, if a person has a Section 8 voucher, they have to base the tenant's portion. I mean, their screening requirements on the tenant's portion for screening.
Thacker's asking, can you increase the rent at a lease renewal, or do you need to provide the proper notice prior to lease renewal? Only time you can raise rent without giving 210 days notice is when the tenant leaves property and you are renting to a new person?
Those two separate, were you answering the question, Raquel, or were you?
No, that's the way it's written.
Oh, okay. Can you repeat it? Because I thought you started answering, so that's why I stopped, because I know you know the answer to some of this stuff. So I apologize.
Nope, just giving you questions. Can you increase the rent at a lease renewal, or do you need to provide the proper notice prior to lease renewal? That's the one. And then it says, only time you can raise rent without giving 210 days notice is when the tenant leaves property and you are renting to a new person, ?
So the first question, if you're going to do a lease renewal that includes a rent increase, you do have to do the proper 210, 180-day notice, and then with the reminder notice at 120 days and 90. So that's the answer to the first part of the question. The second part of the question, if it's a new tenant and they're entering into the rental agreement, you can set the rent as much as you want to, but as they're living there, if you're going to increase the rent, then you now have to follow the provisions of as required by the law for rent increases.
Okay, now we are at 8 minutes. I'm just gonna skim through here and see. Somebody's asking for the termination, the reasons of the 16 just causes or 17 just causes.
So in the city code, you can find those under TMC 1.95.070, and in the state law, it's RCW 5918.650, and that outlines all of the reasons and the notice provisions attached to terminating a tenancy.
Okay, this one, Attorney Chris, if a tenant subleases the property to a subtenant, does the tenant step into the same shoes of the landlord if they don't live on the property?
So if I rent from Nancy and then I rent to Raquel and I don't live on the property, do I step into the same shoes as the landlord? I mean, yes, they would be if they have the permission as from the owner of the property for them to sublease the unit, whether they live on the property or not, they still do have to follow the same provisions for terminating tenancy and notices and rent increases and all that as anyone else.
Al is asking, do I need a rental business license if my rental properties are located in Pierce County?
No, if your property is not inside the city limits of Tacoma, you are not required, as far as I know, for the county to have a business license. If your property is inside the city limits, you have to have a city business license to operate your rental property.
And Melissa's asking, if the rent raise rate is fully disclosed in the lease, does that count as proper notice?
I would speak with your attorney because a tenant may say that, but the way they may agree to that and they're signing leases and a bunch of paperwork, and so they may forget about it. But the way the state law is written and the city of Tacoma's rental housing code, it does say that you have to give proper written notice. So I would suggest you talk to your attorney before putting those types of things into your rental agreements and expecting a tenant to remember and to comply with them.
There are a couple questions about the first month's rent again, so I'm going to ask this one. Grant's asking, as a landlord, we can no longer charge first month's rent, last month's rent, and applicable deposit because you are stating that move-in costs cannot be more than 1 month's rent, correct?
So I would speak with your attorney about the last month's rent, because the city does have provisions in our rental housing code around the fact that a last month's rent can be collected. But the way the initiative is written, it clearly states the deposits, the move-in fees, the pet fees, and different things like that. All of that cannot exceed 1 month's rent. But again, I would speak with your legal counsel to see if you're able to still charge the last month's rent, because that isn't specifically spelled out in the Landlord Fairness Code initiative.
Scott's asking, I have a lease ending on January 31st, 2024. I complied with the city ordinance notice requirement for a rent increase. How can I be in compliance with the new ordinance, or do I need to be?
I would speak to your attorney, because if you've already given the notices under the city's requirements when it before this goes into effect on December 8th, and you've already properly served it and everything was done the correct way, you're in compliance with the city law. But I would speak with your attorney to see if they believe that you are okay with not serving another notice.
I think there's still some confusion on raising rents. Dan's asking, can I raise rents more often than every 12 months? Do you have to wait 12 months before a rent increase?
No, the notice provisions say 7 to 6 months. So if you can do it within, it doesn't have a cap on like how many times you can do it, but if you can give the proper rent increase notice within a 12-month period, then you would be fine. But I would speak with your attorney on that. But yeah, the notice provision is 210 and 180 days, which is 6 months or 7-month rent increase notice for the first notice, and then the 120 and the 90 for the reminder notice. So if you can squeeze 2 in there in that with those 6-month requirements at the minimum, I would speak with your attorney to see if it's possible.
So I think we've covered most of the questions. There's a few questions still in the chat, but they're repeats a bit of others. And just so you all know, the plan is to have some fact sheets on the website. And of course, we're available through 311 or through the website. And this is growing pains for all of us. We're all learning together. And so thank you, Jaquetta. I hope you have another Dr. Pepper there for yourself. But we appreciate everybody who stayed on the line with us tonight. And we know there's questions. We also have questions, and so hopefully this was an introduction to understand what the rental housing code is, and what I'm just going to say LFCI because that's easier is. You know, they are different, but they are both in effect. So we need to comply with both. So again, thanks everybody for being with us tonight.
Can I say something, Nancy?
Yeah.
Again, I would like to thank each and every one of you for attending the training, and most of all for your partnership with the city, because we truly do believe as a city that it is a partnership between the city, the landlords, and the tenants. And I know sometimes it may not feel like that, but that is our goal. And this is, like Nancy said, it's a growing pains for all of us. And so as we're learning, we are going to share information with you guys as we get it. The goal is for us to still have a partnership. And again, as I said earlier, as people are saying that they're hoping to, that they may be getting rid of their properties, that is what the city does not want you to do. We are hoping that we can continue the partnership, that we can all find some kind of common ground, because housing is essential in the city of Tacoma, and we understand that. And so we just ask that you bear with us as we grow with you, as we're learning these things, and we're going to try to have as many trainings and outreaches to ensure that everybody gets a better understanding on what it looks like to operate rental property or live in rental property in Tacoma. So again, I thank you guys for all of your dedication to rental housing in Tacoma and for attending this training. And we will see you in January as we roll out our more in-depth education and outreach plan. So thank you guys.